Good evening, friends. I welcome you all on behalf of Nani Palkhivala National Law Club in this 8th series of Nani Palkhivala birthday celebration that is on 16th of the January. In that, we are at the part 4, which is basically case study of Minerva Mill versus Union of India. This case is basically Minerva Mill is a Sikh textile company which was by government of India. It was taken the monitoring and control of this particular Minerva mill. So the petition was consist of various pleadings, which includes the amendment by which the parliament wants to take the full control and change the basic structure of the constitution. So the issue came with this case that is the constitutional 42nd amendment of the 1976 section 4(5) are constitutional. The second issue is that the 368 clause 4 and 5 constitutional validity. These things are checked in this particular case. The sir will go in the brief in this. We have today Jayprakash Somani, Advocate, Supreme Court of India, founder director of Nani Palkhivala National Law Club, and he will thoroughly analyze the judgment and the pleadings which has happened in this particular case. Over to you, sir.
Thank you. Thank you, Manoj. Friends, Nani Palkhivala was a prominent Indian lawyer and constitutional expert who played a significant role in the landmark judgment of Minerva Mills Limited versus Union of India 1980. This case is one of the pivotal moment in Indian constitutional law, particularly in the context of the balance of the power between the legislature and the judiciary and the protection of the fundamental rights. So note down this specific line. This case is related to in the context of the balance of the power between legislature and the judiciary and the protection of the fundamental right. Background of this case, as earlier told by Advocate Manoj Kumar Chaudhary. So I'm giving little bit background of this case. Minerva Mill Limited was a textile manufacturing company that challenged the constitutionality of certain amendments made to the Constitution of India in the late 1970s. Specifically, the 42nd Amendment, which had been enacted during the emergency period 1975 and 1977. So this emergency period, that period, whatever the constitutional amendment are there, that amendment is to only for to suppress the judiciary, suppress the other system, and only prove superior to the parliament only. So that was so democracy, killing the democracy effort was done at that time in the during particular that emergency period. So this 42nd amendment, this is related to 42nd amendment. The amendment aimed at curtailing the power of the judiciary to review constitutional amendment and strengthen the position of parliament. What my Guru Palkhiwala's contribution in this matter, in this case? Nani Palkhivala represented a Minerva Mill in the Supreme Court. His advocacy was marked by eloquence, clarity, and a profound understanding of the constitutional principles. Arguments. He argued that the amendment violated the basic structure doctrine of the Constitution, the doctrine which emerged from the earlier judgments, that means Keshwananda Bharati, asserted that certain fundamental features of this Constitution cannot be altered or destroyed by amendments. Palkhivala emphasized the importance of fundamental rights and the need to protect them from legislative encroachment. He argued that the amendment sought to undermine the independence of the judiciary and the fundamental right of citizen. Key legal principles which is handled by Palkhivala and other uh, Attorney General of India at that time. So key legal principle which was handled in this case are Palkhiwala's argument contributed to the Supreme Court's reinforcement of the basic structure doctrine established in the Keshwananda Bharati case 1973. He articulated the view that the Constitution is a living document that embodies the aspiration of the people, and any attempt to change its basic tenets is fundamentally flawed. Supreme Court judgment. In a historic ruling believed on January 24, which is delivered on January 24, 1980, the Supreme Court, with the majority opinion, upheld the challenge of the amendments. The court ruled the amendment made by the 42nd Amendment were unconstitutional as they violated the basic structure of Constitution. The judgment reimposed the supremacy of the Constitution and the judiciary's role in interpreting it, thereby restoring the balance of power among the branches of government. Impact and legacy. The Minerva Mills case is now considered a cornerstone of constitutional law in India. It underscored the judiciary's duty to act as a check on the powers of the legislative and executive branches and ensured the protection of individual rights against the arbitrary government's action. Nani Palkhiwala's contribution in this case not only highlighted his legal acumen, but also solidified his position as one of the foremost advocates for constitutional supremacy and the rule of law in India. His mastery in articulating the complexities of the constitutional law has had a lasting impact on legal discourse in India. Some part I will read at the end of the judgment also, but I will now show how Nani Palkhivala argued this case, which points he put before the benches. This is the constitutional bench case. I will read their name. I will read the name of the panel, judges of the panel, which law, which articles of constitution discussed in this, which cases discussed in this. Okay. So this is the overall just a highlight of this Minerva Mills case and the contribution of Guru Nani Palkhivala here. Yesterday, my friend called me, Somani, I want to keep your one lecture in reputed law college in Pune. So on which subject you will speak? So I inform him, be a future Nani Palkhivala. How? So name of subject for law college for my next some month. Those law college wants to arrange this lecture. Physically, it is very impossible for me. Only in Delhi or nearby Delhi, it is possible physically. But virtually, anywhere it is possible. And title will be a future Nani Palkhivala. And how? So what characteristic you should possess to become a future Nani Palkhivala like personality, and how you should proceed your legal career as well as your practice from the lower court to apex court, trial court to apex court. So how you can argue and what are the changes during this COVID period India's legal system has accepted, that is virtual hearing like that. So you can argue case of any court from your home also. So in future, you will find so many things. So if any law college or any bar associations, bar councils wants this lecture, just contact to my PA. Then now I will take you towards that particular judgment, which is more than 100 pages. Near about that page, judgment is near about 124 pages. So friends, the writ petition number of this Minerva mill case was 356-361 of 1977. That means bunch of writ petition was there. This case was decided on 9th May 1980 and delivered on 31st July 1980. Cause title is Minerva Mills Limited and others versus Union of India and others. Honorable Judges Quorum, V.Y. Chandrachud, Senior Chandrachud, who was the longest Chief Justice of India. Yashwant Chandrachud. Chief Justice A.C. Gupta, N.L. Antwalia, P.N. Bhagwati. He is the father of PIL, P.N. Bhagwati, Justice Bhagwati, father of PIL, Public Interest Litigation, and P.S. Kalyasam, judge. So these are the 5 bench judgment. So this is a constitutional bench judgment. For understanding our Supreme Court system, just watch my one webinar, Supreme Court rules. Near about, I have taken that webinar at that time for the AOR aspirant candidates. So you will find their system. So how single judge is moving in Supreme Court, what is a 2-judge bench subject, what is single judge bench subject, what is 3-judge bench subject, what is constitutional bench subject, and how Supreme Court is framing the more than 5 judges bench, like 7 judges, 9 judges recently. One bench was 9 judges and 13 judges. Longest bench was Keshwananda Bharti case. So all the procedure you will comes to know from that my webinar, Supreme Court Rules 2013. So now friends, acts or rules discussed in this case was Bombay Prohibition Act 1949, Section 23A, Bombay Prohibition Act 1949, Section 24, 1A, Constitution of India, Article 1, Constitution of India, Article 2, Article 3, Article 4, Article 5, Article 6, Article 7, then Article 9, Article 10, Article 11, Article 12, Article 13, Article 14. Understand what is the importance of this case? If you study this case thoroughly, how much practical you will be. Because reading a law, reading a constitution, that is a theory. And reading the judgment, so you can get the knowledge about the practical application of the law into the real story of that particular case. So Article 14, Article 15, Article 16, Article 17, Article 18, Article 19, Article 20, Article 21, Article 13.2, Article 141, Article 15.2, Article 19.1, Article 19.1A, Article 19.1D, Article 19.1F, Article 19.2. Very, very important case for your accuracy, legal accuracy. Article 19.5, Article 19.6, Article 22, Article 23, Article 24, Article 25, Article 26, Article 27, Article 28, Article 29, Article 226, Article 250, Article 268, Article 269, Article 270, Article 31, Article 31.4, Article 31.6, Article 31C, Article 310, Article 31A, Article 31A1, Article 31B, Article 31C, Article 32, Article 32.4, Article 329A, Article 329A4, Article 332, Article 338, Article 352, Article 353, Article 354, Article 358, Article 359, Article 368, Article 37, Article 38, Article 39, Article 40, Article 41, Article 42, Article 43, Article 44, Article 45, Article 46, Article 47, Article 48, Article 49, Article 50, Article 51, Article 83, Article 83.2. House of the People Extension of Duration Act 1976, Section 2, which was repealed. House of the People Extension and of Duration Act 1976, which was repealed. Section 211A. Industries Development Regulation Act 1951, Section 15. Industries Development and Regulation Act 1951, Section 18A. Sikh Textile Understanding Nationalization Act 1974, Section 32. Sikh Textile Understanding Nationalization Act 1974, Section 39. So these are the Act rules, articles involved in this case. Case referred. I will not read all the cases referred. So many cases are referred in this, but I will read some of them only. So Keshavananda Bharati, Sripad Gaulwaru versus State of Kerala. Indira Nehru Gandhi versus Raj Mohan and others. The State of West Bengal and versus Anwar Ali Sarkar. The State of Kerala versus Haji K. Kuti Naha and others. Lakshman Das, Keval Ram Ahuja and others versus State of Bombay. Habib Mohammed versus State of Hyderabad. Kanat Thatuni Mupil Nair versus State of Kerala and others. Jia Lal versus the Delhi administration. A. Haji Abdul Sarkor and company versus State of Madras. Devi Das Gopal Krishnan and others versus State of Punjab. So, and so many cases are discussed in this. Now I will give you some brief case note of this case. Some foreign jurisprudence also referred in this case, like that Weber's Constitutional Law 1946, ED PP 68, American Jurisprudence, second volume 16 PP 299-301, Mr. H.M. Servai's Constitutional Law of India, Indian Constitution, Cornerstone of a Nation, edition 1966 was also referred in this. Case note, Constitution Amendment, Article 13, 14, 19, 31A, 31B, 31C, 32, 38, 132, 133, 134, 141, 226, 352, and 368 of the Constitution of India. Remember that this is the series of our webinar, and this is a tapa series. This is not for entertainment. This is for tapa. I will take within 6 months one tapa series. Tapa series means which is for our legal knowledge tapa. Like in a Navratri period, I am doing the tapa of Mount then reading the spiritual books, going to Badrinath, Kedarnath, like that. So that is a tap, that is a spiritual tap. Now we have to complete our legal tap also, because we have to celebrate the late legend Nani Palkhiwala's birth anniversary on 6th January 2025. This will be happen, this grand ceremony will happen in the Krishna Memon Hall opposite Supreme Court Sardi Gate. So before celebrating such a great personalities birth anniversary, that means Jayanti, we should do some tapa. So I am doing this tapa, and you are also participating in this tapa. So just read here again and again such type of tapa lectures, tapa videos, which will enlighten you, which imbibe you the article section of different acts and our constitution. So friends, next, Rules of Article 368.4 and 368.5 introduced by Section 58 of Constitution of India, 43rd Amendment Act under challenge. Article 368.5 confirmed upon Parliament unlimited power to amend the Constitution. Article 368.4 deprives court of its power of judicial review over constitutional amendment. Article 368.5 struck down as a parliament had only limited amending power. Such a limited power cannot be enlarged into absolute power. By expounding its amending power, Parliament cannot destroy its basic structure. Donee of limited power cannot convert such a power into limited one. Article 368.4 prohibiting judicial review violates the basic structure, held Article 368.4 and 368.5 unconstitutional. Now, if you read the Constitution current edition, you will not find these articles. So this judgment was delivered in 1980. So if you read the edition, any edition before 1980 edition, okay, that means 1978, 77, then you will find these articles there, which our apex court declared as unconstitutional. Second, directive principle of state policy, whether directive principles can have supremacy over fundamental rights. Merely because directive principles are not justicable, it does not mean that they are subservient to fundamental rights. Destroying fundamental rights in order to achieve goal of directive principles amounts to violation of basic structure, giving absolute primacy to one over another disturbs harmony. Goals of directive principle should be achieved without abrogating fundamental rights. Directive principles enjoy high place in constitutional scheme. Both fundamental rights and directive principles to be read in harmony. Held amendments in Article 31C introduced by Section 4 of 42nd Amendment Act also unconstitutional. Judgment. What Yashwant V. Chandrachud, Chief Justice at that time told. Section 4 of the Constitution, 42nd Amendment Act 1976, which come into force with effect from January 8, 1977, amended Article 31C of the Constitution by substituting the words and figures all or any of the principle laid down in Part 4 of the words and the figures. The principles specified in Clause B or Clause C of the Article 39, Article 31C as amended read thus. So initially, Justice Chandrachud has given what is the exactly wording of that particular amendment sections. So they have given at initial stage. Then in second para, he has given section 58 of the Constitution 42nd Amendment Act 1976, which come into force with the effect from the January 8, 1977, inserted subsection 4 and 5 of Article 368, which read thus. I will read this because you will not find this section in now current edition. I am reading Article 368, 4 and 5, which was the section inserted by the amendment 42nd Amendment in January 8, 1977. So Article 368(4), no amendment of this constitution, including the provisions of Part 3 made for purporting to have been made under this article, whether before or after commencement of Section 55 of the Constitution 42nd Amendment Act 1976, shall be called in question in any court on any ground. क्या दादागिरी थी यार, हाँ? Whatever we are changing in constitution, that cannot be challenged in any court. And what is 5? For the removal of doubt, it is hereby declared that there shall be no limitation whatever on the constituent power of the parliament to amend by way of addition, variation, or repeal the provisions of this constitution under this article. P.N. Bhagwati just mentioned here, the question which arises for determination in this writ petition is as to whether Section 4 of the Constitution 42nd Amendment Act of 1976, amending Article 31C of the Constitution, is constitutionally valid. I cannot persuade myself to pass an order pronouncing upon this question without a reasoned judgment, since the question is one of the grave and momentous consequence involving as it does the validity of constitutional amendment. I would therefore prefer to pass a final order in this case when I delivered my reasoned judgment on the reopening of the court after the summer vacation. Then V.Y. Chandrachud, Chief Justice, dated 1st July, for himself and A.C. Gupta, N.L. Utwalia, and P.S. Kailasam, judge. Then he gives some 2-3 paras. So I will read on 2-3, which is relevant. All judgment is relevant, but it is not possible to complete in 1 hour or 1.5 hours. Total 122 or 27 pages judgment. It is not possible. But I will give you the glimpse. And main motto is to explain how Nani Palkhivala has contributed in the judgment and how this case is. Only because of these 2 cases, Keshavananda Bharati case and Minerva case, our democracy is protected, friends. Otherwise, if this 42nd Amendment declared as a valid at that time, no constitutional change can be challenged to any court of law then. Not in High Court, not in Supreme Court. What was the situation? But now, fortunately, that was not happened due to this luminary, legend Nani Palkhivala at that time. Para 6. In Keshavananda Bharati, this court held by majority that though by Article 368, Parliament is given the power to amend the Constitution, that power cannot be exercised so as to damage the basic structure of the Constitution or so as to destroy its basic structure. No damage, no destroy. The question for consideration in this group of petition under Article 38 is whether Section 4 and 55 of the Constitution 42nd Amendment Act transgress that limitation on the amending power. Petitioner number 1, which is a limited company, owned a textile undertaking called Minerva Mills situated in the state of Karnataka. This undertaking was nationalized and taken over by the central government under the provisions of the Sikh Textile Undertaking Nationalization Act 1974. Petitioners 2 to 6 are shareholders of petitioner number 1 company, some of whom are also unsecured creditors and some secured creditors. Respondent 1 is of the Union of India. Respondent 2 is the National Textile Corporation Limited, in which textile undertaking of Minerva Mills comes to vested under Section 3(2) of the Nationalization Act of 1974. Respondent 3 is a subsidiary of the second respondent. On August 20, 1970, the central government appointed a committee under Section 15 of the Industries Development and Regulation Act 1951 to make a full and complete investigation of the affairs of the Minerva Mills Limited, as it was opinion that there had been or was likely to be substantial fall in the volume of production. The said committee submitted its report to the central government in January 1971, on the basis on which the central government passed an order dated October 19, 1971, under Section 18A of the Act of 1951, authorizing respondent to take over the management of the Minerva Mills Limited on the ground that its affairs were being managed in a manner highly determined to public interest. By these petitions, the petitioners challenged the constitutional validity of certain provisions of the Sikh Textile Undertaking Nationalization Act and of the order dated October 19, 1971. We are not concerned with the merits of the challenge at this stage. The petitioner further challenged the constitutionality of the Constitution's 39th Amendment Act, which inserted the Impugned Nationalization Act as entry 105 in the 9th schedule to the Constitution. That arises a question regarding the validity of Article 31B of the Constitution, with which we propose to deal in another batch of the petitions. Finally, the petitioner challenged the constitutionality of Section 4 and 55 of the Constitution 42nd Amendment Act, and it is the contention alone with which we propose to deal in this petition. So this is the just background they discussed. Then I will take you to 31 para. The argument of Mr. Palkhivala, who appears on behalf of the petitioners, runs this. The amendment introduced by what Palkhivala says, this is given by the judges in their judgment. So language is judge language. Nani Palkhivala's language was very simplified and very touched language. The Constitution, the amendment introduced by Section 4 of this 42nd Amendment destroyed the harmony between Part 3 and Part 4 of the Constitution by making the fundamental right conferred by Part 3 subservient to the directive principle of state policy set out in Part 4 of the Constitution. The Constitution makers did not contemplate a disharmony or imbalance between the fundamental rights and the directive principles, and indeed they were both meant to supplement each other. The basic structure of the Constitution rests on the foundation that while the directive principles are the mandatory ends of the government, those ends can be achieved only through permissible means which are set out in Part 3 of the Constitution. In other words, the mandatory ends set up out in Part 4 can be achieved not through totalization method, but only through those which are consistent with the fundamental right confirmed by Part 3. If Article 31C, as amended by the 42nd Amendment, is allowed to stand, it will confirm an unrestricted license to the legislature and the executive, both at the center and in the state, to destroy democracy and establish an authoritarian regime. All legislative action and every governmental action purports to be related directly or indirectly to some directive principle of state policy. The protection of amended article will therefore be available to every legislative action under the sun. Article 31C abrogates the right to equality guaranteed by Article 14, which is very foundation of the republican form of the government and it by itself a basic feature of the Constitution. So they are talking about the Article 31C, which was inserted at that time. If you read the Constitution now, current edition of Constitution, and if you refer this judgment, you will get confused. So this point should always kept in mind of which date judgment you are reading. So you have to refer earlier edition. And all are available on government website, all are available on Supreme Court website, all are available on Bombay High Court website, all are available on Delhi High Court websites. So all our editions are available. Don't worry. The Learned Council further argues that it is impossible to envisage that a destruction of the fundamental freedoms guaranteed by Part 3 is necessary for achieving the object of some of the directive principles like equal justice and free legal aid, organizing village panchayats, providing living wages for workers and just human conditions of the work, free and compulsory education for children, organization of the agriculture and animal husbandry, and protection of environment and wildlife, that the Constituent Assembly had rejected by creating a harmonious balance between the Part 3 and Part 4 is brought back by the Article 42nd Amendment. Finally, it is argued by Nani Palkhivala that the Constitution had made provision for the suspension of the right to enforce fundamental rights when an emergency is proclaimed by the President. Under the basic scheme of the Constitution, fundamental rights were to lose their supremacy only during the period that the proclamation of emergency is in operation. Section 4 of the 42nd Amendment has robbed the fundamental rights of their supremacy and made them subordinate to the directive principle of the state policy as if there were a permanent emergency in operation. While Article 359 suspends the enforcement of fundamental rights during the emergency, Article 31C virtually abrogated them in a normal times. Thus, apart from destroying one of the basic features of the Constitution, namely the harmony between the Part 3 and Part 4, Section 4 of the 42nd Amendment denies to the people the blessings of the free democracy and lays the foundation of the creation of authorization state. So friends, can you imagine? Whole country was during the emergency, no freedom to press, no freedom to judiciary, no freedom to anybody. Those who are opposing, they are put in the jail at that time. All were put in the jails. All are jail flooded. And in that era, in that time, argue in such a way in apex court and giving decision very wisely and giving decision very prominently by the judges also. So act of advocates and act of judges, both are admirable in this case. And I admire their courage also. Normal advocate can bow before the government, but strong advocate like Nani Palkhivala only bowed before the constitution only, not before any government. So friends, this we have to keep in mind. Now I will take you to para 42. In support of the submission, reliance in place of the learned council on the decision of the American Supreme Court in Commonwealth of Manchester versus Andrew W. Mellon 1922, 87 L 8 1078, George Ashwender versus Tennessee Valley Authority 1935, 8L ED 688, and Weber's Constitutional Law 1946, AD PP 68, and American Jurisprudence, second volume 16 PP 299-301. Friends, I'm just reading, and Nani Palkhivala has, and all judges had studied that before doing these historical arguments. So studying our citation is a different thing, and studying of different Supreme Court's worldwide citations and putting before the Supreme Court is a different thing. So research team, you must have a very nice research team in your law firm. Single person cannot do such type of things. I am very fortunate with the grace of Lord Krishna. I have 13 associates with me, 5 are AORs, very nice research team and everything there. So we are always trying to give the shape, and we are always keeping in mind the spirit of Guru Nani Palkhivala. Now I am taking towards you on page para 70. Mr. Palkhivala read out to us an extract from the speech of then Law Minister who, while speaking on the amendment to Article 31C, said that the amendment was being introduced because the government did not want the lead and hindrance of the fundamental rights. If the Parliament has manifested a clear intention to exercise an unlimited power, it is impermissible to read down the amplitude of that power so as to make it limited. The principle of reading down cannot be evoked or applied in position to the clear intention of the legislature. We suppose that in the history of the constitutional law, no constitutional amendment had ever been read down to mean the exact opposite of what it says and intends. In fact, to accept the argument that we should read down the Article 31C so as to make it conform on the ratio of the majority decision in Keshwananda Bharati is to destroy the whole purpose of Article 31C as directed by the very heading saving of certain laws under which Article 31A, 31B, 30 and 31C are grouped. Since the amendment to Article 31C was unquestionably made with a view to empowering the legislatures to pass law of the particular description, even if those laws violate the discipline of Article 14 and 19, it seems to us impossible to hold that we should still have Article 31C from the challenge of the unconstitutionality by reading into the article words which destroy the rationale of the article and intendment which is plainly contrary to its proclaimed purpose. Now I will take you to para 121. These consideration which I have discussed above completely answer some of the difficulties raised by Mr. Palkhivala. He said that if the amendment articles 31C were held to be valid, even provisions like section 23A and 24(1)A of the Bombay Prohibition Act 1949, which were struck down in the state of Bombay versus FN Balsara as violating freedom of speech guaranteed under Article 19(1)A would have to be held to be valid. I do not think that freedom and democracy in this country would be imperiled if such provisions were held valid. In fact, after the amendment of Article 19(2), the Constitution, First Amendment Act 1951, it is highly arguable that such provision would fall within the protection of Article 19(2) and would be valid, and even otherwise, it is difficult to see how any violation of basic structure is involved if a provision of law prohibiting a person from commanding any intoxicant, the consumption or use of which is forbidden by law, except under a license issued by the state government, is protected against infraction of Article 19(1)A. The position would perhaps be different if provision is introduced in the Prohibition Act by saying that no one shall speak against the prohibition policy or propagate for the repeal of the Prohibition Act or plead for the removal of Article 47 from the directive principles. Such a provision may not and perhaps would not be entitled to the protection of the amendment Article 31C, even though it finds a place in the Prohibition Act because its dominant object would not be to give effect to the directive principle in Article 47. Lastly, I must consider the argument of Mr. Palkhivala that judge is speaking like that in para 122. Lastly, I must consider the argument of Mr. Palkhivala that almost any and every law would be within the protection of the amendment Article 31C because it would be referable to some directive principles or the other. I think this is an argument of despair. Article 39 to 51 contain directive principle referring to certain specific objective, and in order that a law should be for giving effect to one of those directive principles, where would have to be real and substantial connection between the law and specified objectives set out in such a directive principles. Obviously, the objectives set out in these directive principles being specific and limited, every law made by legislature in the country cannot possibly have a real and substantial connection with one or the other of these specific objectives. It is only a limited number of laws which would have a real and substantial connection with one or other of the specific objectives contained in these directive principles, and any and every law would not come within its category. Mr. Palkhivala then contended that in any event, the directive principle contained in Article 38 was very wide and it would cover almost any law enacted by a legislature. This contention 1% also not well founded. Article 38 is a general article which stress the obligation of the state to establish a social order in which justice, social, economic, and political shall inform all the institutions of national life. It no doubt talk of the duty of the state to promote the welfare of the people, and there can be no doubt that standing by itself, this might cover a fairly wide area, but it may be noted that objective set out in article is not merely promotion of the welfare of the people, but there is a furtherance, further requirement that the welfare of the people is to be promoted by the state, not in any manner like, not according to its whim and fancy, but for securing and protecting a particular type of social order, and social order should be such as would ensure social, economic, and political justice for all. Social, economical, and political justice is the objective set out in the directive principle in Article 38. And it is this objective which is made fundamental in governance of the country, and which the state is led under the obligation to realize. The directive principle form the base on which the entire structure of the directive principles is reared, and social, economic, and political justice is the signature tune of the other directive principles. The directive principles set out in the subsequent articles following under the Article 38 merely particularize and set out facets and aspects of the idea of the social, economic, and political justice articulated in Article 38. Mr. Palkhivala's complaint was not directed against the use of the words political justice in Article 38, but his contention was that the concept of social and economic justice referred to as that article was so wide that almost any legislation could come within. I do not agree. The concept of social and economical justice may not be very easy of definition, but its broad contour are to be found in some of the provisions of the fundamental rights and the directive principles, and whatever the question arises whether a legislation is for giving effect to social and economic justice, it is with the reference to these provisions that question would have to be determined. There is nothing to vague or indefinite about the concept of social or economic justice that almost any kind of legislation would be justified under it. Moreover, where a claim for protection is made in respect of a legislation on the ground that it is enacted for giving effect to a directive principle, the directive principle to which it is claimed to be related would not ordinarily be general directive principle set out in Article 38, but which be one of the specific directive principles set out in the ascending articles, such as I said before, their latter particularize the concept of social economic justice referred to in Article 38. Friends, now I will now give you some summary points of this Minerva case. So this is my concluding part now. The Minerva Mill case is a significant landmark judgment by the Supreme Court of India that took place in 1980. I'm not repeating again. I'm giving this point, different points. Here are the key points regarding the case. Background: the case arose from the dispute involving Minerva Mills, a textile manufacturing company in India. The company's management was in conflict with the government regarding its operation and certain modification to the law affecting its business. 2. Constitution context. The case was pivotal in examining the relationship between fundamental right and directive principles of the state policy as enshrined in the Indian Constitution. It assessed how amendment to the Constitution affected these rights. 3. Amendment of the Constitution. The case specifically dealt with the validity of 42nd Amendment to the Constitution, which was enacted during the emergency period 1975 to 1977. This amendment sought to curtail judicial review and emphasize the primacy of a directive principle over fundamental rights. 4. Judicial review. The Supreme Court reaffirmed the basic structure doctrine established in the Keshwananda Bharati case. The court held that the power of judicial review is part of the basic structure of the Constitution and cannot be abrogated or diluted. 5. Fundamental rights versus a directive principle. The ruling clarified that while a directive principle aimed to guide the state in policy making, they cannot override fundamental rights. The court emphasized that both must coexist and fundamental right serve as a safeguard against the state action. 6. Decision. The Supreme Court ruled against the validity of certain provisions of the 42nd Amendment that attempts to restrain judicial oversight, hereby reinstating the balance between fundamental rights and directive principles. 7. Impact on Indian jurisprudence. The case significantly influenced the evaluation of constitutional law in India, reinforcing the nation that any amendment that affects the basic structure of the Constitution is impermissible. 8. Judgment significance. The case is often cited for its emphasis on the democratic values of justice, liberty, and equality, and it has been referred in subsequent cases concerning constitutional right and state policies. 9. Result. The judgment upheld the right of citizen and reiterate the importance of the judiciary in upholding the constitutional governance. This landmark case thus stands as a key reference point in discussion on the constitutional law, fundamental rights, and limits of governmental power in India. So, friends, this is our part 4, and only part 5, 6, 7 are balanced on webinar, and 8 part will be our live that grant program, which we will plan to take in Supreme Court, opposite D gate of Supreme Court premises in Krishna Memon Hall. Friend, if you are out of Pune, also out of Delhi, then if it is possible, you attend that. We will try to make it live on YouTube also at that time. So if you are not able to attend, then you can watch that live on YouTube also. We will record that also. We'll later on put that on YouTube also. But attending such type of function lively, physically, will get a different aura to you, to all the legal, future legal luminaries, I would like to say. So this is from my side. in today's this part 4. Now, over to you, Mr. Manoj Kumar Chaudhary, Advocate, Supreme Court of India.
Thank you, sir. Such an elaborated analysis of the case Minerva versus Union of India. In one line, what I can say that the Parliament cannot use its limited power authority to grant an unlimited authority. That is the main crux of case law. Thank you, participants. Once again, we'll be in another part 5. Thank you very much, sir, once again.
Yes, thank you. And one message in message box. Kindly share this recorded video. So every recorded video we are sharing within 24 or 48 hours on YouTube, and the link will be shared only in Nani Palkhivala National Law official group 1 and 2. So link we are sharing only in that group. If you are not the member of that group, so that official group, Nani Palkhivala official part group 1 and official group 2, that if you are in that group, you are authorized member of Nani Palkhivala National Law Club. There is no membership charges, no membership any procedure. If you are the member of that group, you will be the member of Nani Palkhivala National Law Club. So Nani Palkhivala National Law Club have at present more than 1,500 members who are enjoying this legal yagya every week, twice every week, once, like that. So be a part of our judiciary. If we advocates are strong, and if journalists are strong, then we can protect our democracy forever, friends. Forever. Okay. Thank you. Thank you very much.
नमस्कार, मैं पूजा राय आपको एडवोकेट जयप्रकाश सोमानी जी का थोड़ा सा परिचय करके देती हूँ। जयप्रकाश बंसीलाल सोमानी सर्वोच्च न्यायालय में अधिवक्ता हैं। 12 जूनियर के साथ वो लॉ फर्म चलाते हैं, जिसमें 5 AOR हैं। सोमानी जी भारत के हर राज्य और केंद्र शासित प्रदेश के मैटर बखूबी हैंडल करते हैं। सुप्रीम कोर्ट केस लॉ के ऊपर उनकी 61 किताबें प्रकाशित हुई हैं, जो Amazon और फ्लिपकार्ट पे अवेलेबल हैं। लिंक आपको नीचे डिस्क्रिप्शन में मिल जाएगा। भारत के लगभग सभी हाई कोर्ट और डिस्ट्रिक्ट कोर्ट के अधिवक्ता इन किताबों का उपयोग करते हैं। अगर आपको सोमानी जी की गाइडेंस अच्छी लगती है तो नीचे कमेंट बॉक्स में जरूर लिखें और अपने दोस्तों के साथ शेयर करना ना भूलें। हाँ, अगर आपने चैनल को सब्सक्राइब नहीं किया है तो सब्सक्राइब कर लें और बेल आइकन को दबाना ना भूलें, ताकि हमारा कोई भी नया वीडियो आता है उसका अपडेट आपको मिल सके। जय हिंद।